Hey everyone, $928 million. That is not a defense contract. That is not a disaster relief fund. That is the amount of American taxpayer money the federal government just handed to a French oil company. Not to build something, not to create jobs, not to solve a problem. To stop building something. To walk away from clean energy projects off the coast of New York and North Carolina. And then to take that same money and pour it into oil and gas drilling in Texas. 7 state attorneys general filed a federal lawsuit the moment the details became public. New York, Connecticut, Maine, Massachusetts, New Jersey, Rhode Island, Vermont. All of them in the same courtroom, making the same argument. This is not policy. This is a federal government using your tax dollars as a weapon against its own states. By the end of this video, you are going to understand exactly what happened, why it matters far beyond clean energy, and the specific legal mechanism the federal government used that every American should know about. There is a line in this lawsuit that should stop you cold. We are going to read it together in about 10 minutes. And there is a number buried in the TotalEnergies deal that the financial press walked right past. That number tells you something the press releases will never say. Pull up the calendar, because the dates do all the work here. March 2nd, 2026. The Trump administration, having already lost multiple rounds in federal court trying to shut down offshore wind projects through standard regulatory channels, pivots to a strategy nobody saw coming. Instead of fighting in court, they cut a deal. The federal government signs a direct agreement with TotalEnergies, the French energy giant, to cancel 2 offshore wind lease agreements. The Attentive Energy 1 project off the coast of New York, the Carolina Long Bay project off the coast of North Carolina. In exchange, the federal government commits to paying TotalEnergies $928 million, $795 million for Attentive Energy, $133.3 million for Carolina Long Bay. But here is the part that turns this from a policy disagreement into something else entirely. As a condition of receiving that $928 million, TotalEnergies agrees to 2 things. First, the company will not develop any new offshore wind projects in the United States. Ever. Second, the $928 million will be reinvested into a liquefied natural gas facility in Texas and into American oil and gas drilling operations. Read that sequence again. Federal government pays a foreign company nearly $1 billion of American taxpayer money. Foreign company agrees to abandon renewable energy in America. Foreign company redirects that $1 billion into fossil fuel infrastructure in Texas. That is the deal. That is what your money bought. Now let's talk about what was actually being canceled. Because the Attentive Energy 1 project was not a speculative bet on future technology. It was a fully permitted, shovel-ready infrastructure project that New York had been building toward for years. TotalEnergies purchased the offshore lease rights in 2022 for $795 million. That is not a small check you write on a whim. That is a company making a serious long-term commitment to a specific piece of ocean real estate off the New York coast. Here is what that project was supposed to deliver. Power for 1.3 million New York homes. $10 billion in savings on energy bills over the project's lifetime. More than 1,700 unionized jobs. $25.6 billion in total economic benefit to New York State over 25 years. And here is the number that should be in every headline. TotalEnergies paid $795 million for that lease in 2022. The federal government just paid them $795 million to give it back. The American taxpayer just bought back a lease that a private company already paid for, and then handed that lease to nobody. The project is gone. The jobs are gone. The $25.6 billion in economic benefit is gone. And TotalEnergies walks away with every dollar it originally spent, paid back in full by you. Now I want to talk about how this was funded, because this is the part the lawsuit is built around and the part nobody in the mainstream press has properly explained. The federal government is planning to use something called the Judgment Fund to pay TotalEnergies. Write that down, the Judgment Fund. It is a permanent, indefinite federal appropriation, meaning it never runs out and Congress never has to vote to refill it. Specifically designed to pay court judgments and legal settlements against the United States government. When the federal government loses a lawsuit and owes someone money, the Judgment Fund pays it. That is what it exists for. Here is what it does not exist for. Paying companies that have not sued the federal government. paying companies as an incentive to abandon projects the administration dislikes, paying foreign energy corporations to redirect their capital into industries the administration prefers. The seven-state coalition's lawsuit is explicit on this point. There is no pending litigation between the federal government and TotalEnergies. There is no court judgment. There is no settlement of a legal dispute. There is just a deal. And using the judgment fund to pay for a deal, rather than a judgment, is, in the coalition's words, an illegal pay-not-to-play scheme. That phrase is important, pay not to play, because what it describes is a federal government using a permanent taxpayer-funded mechanism to pay private companies for not doing things the administration disapproves of. If this deal is allowed to stand, the legal template it creates is extraordinarily dangerous. Any energy company holding a permit or a lease the administration dislikes can now approach the federal government and say, "Pay us to walk away." And the administration can dip into the judgment fund, which again, Congress does not need to approve, to write the check. The lawsuit names Interior Secretary Doug Burgum as a defendant. It argues the cancellation violates the Outer Continental Shelf Lands Act, which is the federal law governing offshore energy leases. Under that law, the Interior Department cannot cancel a valid lease without holding a formal hearing, presenting evidence that the project poses a serious danger to human life, property, national security, or the environment, and making a documented finding to that effect. None of those steps happened here. There was no hearing, there was no finding, there was a deal. The law requires a process. The administration skipped the process and went straight to the payout. Now let's zoom out for a second. Because this is not the first time the Trump administration tried to kill these specific projects. Empire Wind, Sunrise Wind, both of those New York offshore projects were previously halted by the administration on national security grounds. Both of those halts were struck down in federal court. The administration lost, twice. So instead of appealing again, they found a different mechanism. They found the judgment fund. They found TotalEnergies. And they structured a deal that achieves the same outcome. Offshore wind project dead, money flowing to Texas fossil fuel infrastructure, through a channel that had never been used this way before. This is the part I want you to sit with, because the strategy here is not about one French energy company and two offshore leases. The strategy is about what happens next. If this deal survives the lawsuit, every other offshore wind developer holding federal leases is now in a new world. A world where the federal government has demonstrated it will pay companies to abandon projects rather than fight them in court. A world where the judgment fund is available as a tool for that purpose. A world where the blueprint is public and the price tag is known. The seven-state coalition understands this. Their lawsuit is not just about the $928 million or the Attentive Energy Project. It is about whether this model can be used again and again, and whether there is a legal mechanism to stop it. Let's talk about the states for a second. Because the coalition filing this lawsuit is not a group of environmental activists. These are 7 sitting state attorneys general representing a combined population of roughly 40 million Americans. Letitia James of New York, the attorneys general of Connecticut, Maine, Massachusetts, New Jersey, Rhode Island, and Vermont. Their argument rests on 3 pillars. First, the OCSLA violation. The Interior Department canceled valid leases without following the legally required process. Second, the illegal use of the judgment fund. The fund was used to pay a company with no pending legal claim against the federal government, which is not a purpose the fund legally exists for. Third, the broader pattern of weaponizing federal authority against state energy priorities. The states have binding clean energy commitments. New York's Climate Leadership and Community Protection Act requires the state to reach 70% renewable electricity by 2030. The federal government canceling the offshore wind projects that were supposed to deliver a significant portion of that 70% does not just cost money. It potentially puts states in violation of their own laws. And here is where this story intersects with everything else happening in the American economy right now. The states that are filing this lawsuit are the same states already hemorrhaging corporate headquarters, financial firms, and billionaires to Texas and Florida. New York is running a $5.4 billion structural budget deficit. New Jersey just lost Samsung after 8 months and ExxonMobil after 144 years. These states were counting on the offshore wind industry not just for clean energy targets, but for jobs, for union contracts, for tax revenue from construction activity, for the kind of industrial investment that partially offsets the corporate departures happening everywhere else. The Attentive Energy project alone was 1,700 unionized jobs and $25.6 billion in economic activity over 25 years. That is not a rounding error in a state running a multi-billion-dollar deficit. That is a load-bearing economic pillar being knocked out with a federal checkbook. And the money used to knock it out, $928 million of it, is now heading to Texas. This is the part that the financial press keeps missing because they are covering each story in isolation. The offshore wind cancellation and the corporate exodus and the budget deficits and the billionaire departures are not separate stories. They are the same story. They are all chapters in the same structural economic narrative about what happens when the federal government and high-tax state governments are simultaneously pulling the economic foundation out from under the same group of states. One side is taxing the capital away. The other side is canceling the infrastructure investment that was supposed to replace it. The death spiral does not need one cause. It runs on multiple inputs at once. And right now, New York has all of them running simultaneously. So here is where this stands. 7 states in federal court arguing the administration violated 2 separate federal laws and used a taxpayer-funded mechanism for a purpose it was never intended for. A French energy company that paid $795 million for an offshore lease got every dollar back without building a single turbine and agreed to reinvest it into Texas oil and gas. 1,700 union jobs that will not exist, $25.6 billion in economic activity that will not happen, and a legal template, if the deal survives, that every other offshore wind developer in America is now looking at very carefully. The lawsuit will take years. The projects will not wait. The jobs will not pause while the attorneys general litigate. And the $928 million is already committed. The receipts are public. The deal is documented. The judgment fund mechanism is in the court filing. The only question is whether the courts agree that using a permanent taxpayer appropriation as a pay-not-to-play scheme for federal energy policy crosses a legal line that cannot be crossed. And the answer to that question will determine whether this was a one-time political maneuver or the opening move in a much longer playbook. If you want to know which offshore wind project is next on the list, and based on the pattern of federal actions over the past 18 months, there is a very specific project in a very specific state that fits every criterion this administration has used before. Subscribe before you scroll, because the next video is the case file. The documents are already public, the timeline is already building, and by the time the press catches up, the deal will already be done. The math does not care about the politics. It just keeps running.